Thank you. Then, so that's the first issue. And as I say, we can tick because we dealt with it yesterday. The second issue, there's just one thing, one question literally that I'll ask you to bring that one from the air, hopefully. Okay. Then the second issue is about the so-called rogue unit. And there are two issues. One is the existence of the unit, which I think is common cause, at least up to 2014. It's common cause. Whether it continued thereafter and so on as the PP believed, or it stopped, that's another issue of dispute. But at least as far as its existence is concerned, we are one, me and you, correct?
I hear you, Chairperson.
Thank you. Right. Now, so that issue is also almost covered. And let me just pause and say this, Chair. And again, this is for the benefit of the members. It is true that it's not the business of this committee to determine whether there's a rogue unit or no rogue unit and so on. That's for Skakane and KPMG and all those people. Of course, if we go as far as to establish that, then it might be a shortcut, but that's not your main focus. Your main focus is whether the belief by the public protector that is indeed so was outrageous and impeachable. That's really the only issue for you. Yeah. So the third issue then, Mr. van Loggerenberg, which really goes to the nub, and I know there's some debates about it, but I'm sure it will be clear in due course to those to whom it's not clear, is that the court findings to the effect that the public protector's views on all these matters were outrageous, or all sorts of adjectives that are used, mischievous, fallacious, what have you, that those conclusions on the facts that will be placed before this tribunal are unjustified. Okay, that's probably the biggest job for us. It's not for you, yeah. But we will lead some of that evidence via you to the extent that it is relevant to you. Do you understand that?
I hear you, Chairperson.
Thank you. But do you understand? Yes, I know you're here.
Yes, you are explaining the big five. I hear the big,
yes.
I mean, I'm
Okay.
up to big three.
Right. That's fine. Now, the fourth issue is that, and that's a broad issue related to the third one, is that the gist of the court findings is that, I'm avoiding to use the term fait accompli, but what I mean is that there was really no investigation. She was just going through the motions with a predetermined outcome. And that is also a theme that comes from both your evidence and some of the judgments. Understand that?
Yeah, you, Chairperson.
Yeah. All right. And then out of those, I'm going to pick out one so that I don't have to go through all of those, like Skakane, KPMG, what have you. We've dealt with most of that. So I'm going to demonstrate this fact by you and I discussing the IGI report in relation to your views on it, but also in relation to the comments made by the court. And just to show again that her conduct regarding the IGI report was actually justified and commendable, firstly, but secondly, that she's not a sangoma. In other words, she would really have known, for example, that your review would be granted a year later. But I don't think you and I will quibble about that. Understand that one?
I hear you, Chairperson.
Okay.
Now, yeah, I now have all 5 of the big 5.
Thank you. Yes, that's the big 5. So I'm going to then go, as I say, the first one is done. The only thing about the first one is I want to ask you to confirm that you, at some stage, deliberately used the wrong surname, a surname that is misspelled, not necessarily that you called yourself Van der Merwe or something, but you used the surname that, and I'm saying that in the context that it might have contributed to your untraceability, not to cast aspersions on you. You used a surname that was the wrong one, misspelled. Correct?
If on my email, yes, Chairperson.
Yes.
My official email. I didn't deliberately do it, but it was just, in fact, if you look at the correspondence between Parliament and my attorneys, my surname is spelled incorrectly again. It's a difficult surname. It's actually Van Loggerenberg.
Loggerenberg.
Van Loggerenberg. Yeah.
Yes, Chairperson.
Okay. Yes.
It's been used in multiple formats over my lifetime.
Okay. Yes. Okay. And again, I'm saying, when I say deliberately, don't take me wrong.
Just pause, Advocate.
So sorry, Chair.
Sorry, Mr. Mpofu, can I just check? Are you putting to Mr. Van Loggerenberg that it's because his surname was wrongly spelled that he wasn't able to be found? Is that the version being put?
No. Yes. Thank you.
Okay.
Yeah.
Proceed then.
Thank you. I'm saying, Mr. Van Loggerenberg, again, I'm not fighting with you. I'm saying, when I say deliberately, I'm saying that you were aware that this was happening and you, let's call it, condoned it. Not that, I'm not saying you are the one who went there and doctored
Yes. No, I never had an issue with it because I understood many people have difficulty with the surname, as do I. I didn't select it. All the people who ever spoke with me knew it was me. So it was fine. It's not an issue.
Yeah, but I'm just saying, if someone didn't speak to you, if I, for example, wanted to find you, and if I Google the wrong surname because I've got the wrong surname, then obviously I'm not going to find you. Obvious. Let's say sure. in some database, correct?
Yeah, no, sure, certainly.
Thank you. Right. Okay, so that's the end of the number 1, Chair. That's all I need for you as far as the one of the big 5. All right. Then on the second one, excuse me, again, I don't want to get into a debate with you as to whether the so-called rogue unit still exists and so on. We'll canvass that with other witnesses. In any event, even if it still existed, you left SARS at 2015. That's common cause.
Yes, Chairperson.
Thank you. So, okay, Chair, that then covers that because, as I said, on that one, it's existence and continuation. Existence is common cause, but at least, again, I don't want to misrepresent the evidence. Existence is common cause up until 2014. Continued existence, we've just covered. Okay, good. Then,
sorry, Chairperson, if I may add to my answer, please.
Yes, go ahead.
Sorry.
It has always been part of the propaganda that the existence of the investigative unit that had the 3 names that I identified in my evidence in chief was somehow denied or kept undercover or whatever the case might be throughout the years of its existence. I just want to emphatically say that That was never the case, and the evidence put before the court in my 4 affidavits quite clearly demonstrate that. Thank you, Chairperson.
Thank you, Chair. And for the avoidance of any doubt, I want to put it on record that I agree with you on that proposition. The existence of the unit, people quibble, I call it the so-called rogue unit, you call it the high-risk unit or whatever, that's, let's put that aside. But the fact that there was such a unit has not been denied, and actually is undeniable. There are 2 issues, 2 aspects, which I want to canvass with you. Oh, well, which I would have wanted to canvass with you, but I can only canvass one of them. The one is this issue of the continued existence, but it would be unfair because let's assume somebody restarted it in 2016 when you were gone. I can't ask you about that. So I think we've both accepted that. But the second issue, which is really where the bone of contention, for lack of a better word, is the rogueness, if you know what I mean, of the unit. That's obviously hotly contested. You would agree?
Yeah, it's hotly contested between you and I, Mr. Mpofu, Chairperson.
Okay, no, I thought you were just talking general. I'm saying it might be hotly contested between you and I, but I'm saying generally that's the issue that has been playing itself out there, outside of you and I. I agree, you and I have contested it, but I'm just saying that's the issue, whether it's rogue, quote unquote, meaning it is unlawful or in breach of the Constitution and that kind of thing. You agree that that's the contested terrain?
Yes, Chairperson, the first time that that unit was referred to in that manner was on 12 October 2014 in the Sunday Times on a front page article with the headline, SARS bugged Zuma. The article claimed that this unit and members of the unit had broken into the private home of former President Jacob Zuma and planted listening devices in his home and secretly and unlawfully listened in on conversations that transpired in that premises. It also made claims of the unit having been involved in tarnishing the reputations of certain former South African Revenue Service officials. Following that, there's a string, I think about 54 claims, such as that the unit acquired new homes, it had slush funds in excess of 600, and in other cases, 800 million rands. It purchased new vehicles, it purchased all sorts of sophisticated spyware, in particular a grabber, and so forth. It also infiltrated politicians as bodyguards. It conducted house penetrations, and so forth. There are a long list, 54 of them, in fact. And it is then in that context that every time that article, those articles appeared over 2 calendar years, that instead of referring to that unit as its convention within the Revenue Service, it was referred to in that manner.
Yeah, thank you. Again, I agree with you. All I wanted to establish for the purposes of this committee, again, because we have to focus it to the work that we're doing here, is that you would agree with me. I'm putting a proposition to you so that you agree or disagree, that apart from you and I, out there are South Africans, I don't know how many, who will agree with you that the unit was above board, nothing wrong with it, and so on and so on. There's another large number of South Africans, again, I don't know how many, who believe that the unit was unlawful and rogue and all the things you've just enumerated. And I'm asking that question to demonstrate that it's not the function of this committee to resolve that public debate. The function of this committee is simply to find out whether the findings of the public protector in that regard were wayward and outlandish and ridiculous or
I
whatever.
understand, Chairperson.
Yes, thank you.
No, it's so. That is unfortunately how a successful propaganda campaign works. The label will remain for long beyond our lifetimes, I'm certain.
100%. And we just want to know that to the extent that the propaganda must have worked on the public protector, whether that's outlandish or not. Okay? All right. Now, that's fine. So, I'm sorry. You and I, on that topic, then I'm just going to ask you a few questions. You accept that, among other things, the public protector, rightly or wrongly, and I'll come back to the rightly or wrongly, I'm just packing it. In coming to her conclusions about the rogueness, quote unquote, or let me use a more neutral term, the unlawfulness and unconstitutionality of the unit had, among other things, the following information at her disposal. The Sikakane report, which found that the unit was unlawful. Okay, sorry, do you agree with that? I'm not saying you agree with the Sikakane report. I'm saying, do you agree that that's one of the materials that she had at her disposal?
Indeed. The way I understand it is that the public protector accepted the Sikakane report as is.
Yes, good. And the second material on which she relied for that belief was the KPMG report, correct?
Correct, Chairperson, but she did not take into account the withdrawal.
Yes, Mr. Okay, we'll come to that, Mr. In fact, we won't.
In other words, we
won't come to that.
Put it differently, she relied on the original KPMG report.
Yes, in respect of which and you'll correct me because you're more familiar with this, you issued a media statement vigorously contesting the extent of that withdrawal. In other words, you were saying KPMG did not withdraw some of the evidence, the body of the evidence, but they only withdrew the conclusions, and you were aggrieved by that, correct?
Yes, I was aggrieved that they only withdrew the conclusions, recommendations, and legal opinions.
Thank you very much. So even you understood that that withdrawal was not complete, hence you were aggrieved.
Correct.
Thank you. Now, the only other thing then I want to say about KPMG is that you part of the material that or part of your qualms with the extent of their retraction was the fact that it left some parts of it untouched, and just accept that for now as a general statement, because that's not the nub of my question. The nub of my question is that in those parts that were not withdrawn, and I'm using that term loosely, was, among other things, the list of what they regarded as interception equipment, intelligence type of equipment, quote unquote, which would be evidence of the rogueness. I'm paraphrasing, but that's among other things, that was part of your gripe, correct?
No, because they did not ascribe the equipment to the unit in question.
What did they ascribe it to?
They just used the term SARS.
Yes, I hear you. Okay, no, fair enough. And again, so that was part of the gripe, that they listed all this quote unquote rogue equipment and simply ascribed it to SARS without allocating it to a particular unit. That was one of your gripes, correct?
Yes, it was certainly.
Thank you. Okay, no, that's good enough for our purposes. Right. Then okay, so that was the second thing. So that's the Kakane, KPMG. And then the third thing that was at the disposal of the public protector was the Kruon report, correct? Kruon
No,
panel.
there was no Kruon report.
Okay, yeah, okay, let's call it Kruon panel
Press
whatever
release.
document,
The press release.
whatever, yes. Press
That's the
release.
title at the top of the document.
Absolutely, I'm with you. Today we're agreeing on everything. Yeah, I'll take yours. Kruon press release number 3, correct?
Thank you, Jay.
Thank you. And then the fourth material that was relied on was the Inspector General of Intelligence report, correct?
No, Chairperson, incorrect.
No, well, I don't understand.
Well, the report says that Ms. Mkhwebane did not have the report.
Which report? The
Inspector General of Intelligence report.
No, sorry, that was a confusing question. So what you are saying is the PP's report says that the PP did not have the IGI report. So, the word
Correct,
report
correct.
was ambiguous. That's what you're
Correct.
trying. Okay. All right. But you accept that she must have relied on it because she, even in the PP's report, refers to its recommendations that you must be criminally charged.
I don't accept that because I don't want to place myself in the shoes of Ms. Mkhwebane. I think Ms. Mkhwebane can explain that herself.
Fair enough.
All I know is that the report emphatically states she did not have the report. She had certain aspects thereof on good authority. How she verified whether those aspects on good authority were indeed what was contained in the report or not, I cannot say. I have my views, given the fact that we now know that she was in fact in possession of the report, but the report states otherwise.
Okay. Thank you. Looks then if Chair, again, I'm doing this to try and speed things up. So I'm just going to sit on this just for a short while, Mr. Van Loggerenberg, because I want to kill 2 birds with 1 stone, so to speak. Search it. Yeah, good. 113. Okay. Whoever is operating the IT system, can you go to paragraph 113? Of the judgment. The one we're talking about, 48521. The rogue unit judgment.
Okay, just a pause there so that we get it flighted.
While we are at it, while they're finding the thing, I just want to confirm. So you're saying you're basing this theory on the fact that in the report, Advocate Mkhwebane, as you put it, emphatically stated that she did not have the report.
Yes,
correct?
Joseph.
Thank you. All right. Okay, well, again, to save time, Chair, I'll just ask the next question while they're looking for the thing.
Please go ahead.
Yes. And the issue I'm going to demonstrate when I say kill two birds with one stone is that you are so wrong with what you've just said. And so is the judgment. So that's what I mean by kill two birds with one stone. So wrong. Like, so wrong. So what you've just said is Advocate Mkhwebane says in the report, emphatically, as you say, that she did not have the IGI report. Where in the report does she say that?
We'd have to find that for you, Chair, if you can allow me a few minutes.
All right, I'll assist you.
All right.
If you have the report in front of you, you'll find the IGI. Sorry. Section. Sorry, I thought I had marked it. All right, I'll find it for you now, Mr. Van Loggerenberg.
Advocate Mpofu, can I assist what you're looking for?
Yes.
The report.
The part in the report, the section that deals with the IGI report.
Could be around paragraphs 5225 on page 4264.
Yes, you're quite right. 5225. Actually, it starts at 5. Oh yes, I know it's confusing because it's under the heading Sikhakhane report, but I'll also explain why that is so. Let's deal with that very quickly. Do you accept that in the report, it is clear that the IGI report is a product of the Sikhakhane report? In other words, one of the findings or recommendations of Advocate Sikhakhane was that the matter must be referred to the Inspector General.
No, Chair, no, I don't accept that.
You don't accept that? All right. All right, no, I'll assist you, don't worry. Relax. So if you go to the report at, my learned friend is almost correct. It starts at 5216 under the heading Sikhakhane report. And it answers also one of the questions that Honorable Gondwe raised about who commissioned what. The first 5216 says the Sikhakhane report was commissioned by the former SARS Commissioner, Mr. Ivan Pillay, to conduct an investigation into allegations of impropriety against Mr. Johan van Loggerenberg, SARS Group Executive Projects, Evidence Management and Technical Support, Mr. van Loggerenberg. The report outlined, amongst other things, issues pertaining to the intelligence unit. So you see how that starts. You confirm that part. Or rather, you can't dispute that part, that it was commissioned by Mr. Pillay to look into your conduct.
Yes, it was not the unit, my conduct in relation to allegations made by Ms. Belinda Walter. It was very specific.
Mr. van Loggerenberg, do you confirm that paragraph?
I confirm it up to where my surname ends with closed brackets.
All right, that's fine. You can confirm it to wherever you want. Yeah. All right. Now, here's the part that you seem to be contesting. Go to the paragraph that my learned friend was referring us to, 5.2.25. And it says the report recommended, in other words, the Sikhakhane report recommended that the activities and functions of the SPU be investigated by the Inspector General of Intelligence. Are you contesting that plain fact?
No, I did recommend that.
Good, thank you. All right. And that's what I was trying to say. You seem to be contesting that. I was saying the IGR report is therefore the product of the Sikhakhane report because it was recommended thereby.
No, Chair, that's what I'm contesting, precisely that point. In order for you to understand the genesis of the Inspector General of Intelligence report, which is in terms of Section 7 of the Intelligence Oversight Act, it was commissioned by the then Minister of State Security in August 2014, in terms of Section 7B of that Act, with a very specific mandate, scope, and purpose.
Okay, Mr. van Loggerenberg, I'll grant you that. I don't care whether it might have been a coincidence. All I'm saying.
Coincidence, Chair.
No, listen to me, please. You don't answer before I finish my question. I'm saying the fact that Advocate Sikhakhane recommended that this matter goes to the IGI, and the fact that they may also have been doing it, I don't care if it's a coincidence or not. All I was saying to you is to establish the facts. The fact which you and I have agreed on is that Advocate Sikhakhane recommended that the issue of the unit be referred to the IGI. Yes?
Yes.
Thank you.
By the South African Revenue Service.
Whatever, yeah.
Okay. Not whatever, Chairperson, it's important. Okay. The recommendation by Advocate Sikhakhane was that the South African Revenue Service should refer the matter to the Inspector General of Intelligence.
Fine.
Thank you. Just a pause.
Sorry, Chairperson.
Advocate Bauer.
I'm hoping to shortchange us by just reading out what the recommendation was from the Sikhakhane Commission so that we don't go around in circles as to precisely what it was. If that would assist everybody.
Sorry, I didn't hear that.
I'm hoping to clear this up quickly by just reading out what the recommendation was from the Sikhakhane Commission.
Yes. No, I'm talking about the report. The PP's report.
No, but you're going around in circles, it seems.
No, I don't appreciate that. I'm not going around in circles. I'm reading the report recommended that the activities and functions of the SPU be investigated to the Inspector General of Intelligence. What circle is that? It's here.
Well, that's in the PP report.
Yes, but that's what I'm dealing with.
But the debate you're having with Mr. van Loggerenberg is whether that recommendation was actually made by the Sikhakhane Commission.
No, I don't. I just said I don't care about that. I don't know why you're telling me. I've just said I do not care whether it was a coincidence or whether it was there or not. I'm reading words here. Okay. And you're telling me that I'm going in circles. The report of the public protector says the report, and when it says the report, it means the Sikhakhane report. You understand that, Mr. van Loggerenberg?
Should I?
Yes, Chairperson.
Yes. So let's read it together in straight lines, not in circles. The Sikhakhane report recommended that the activities and functions of the SPU be investigated by the Inspector General of Intelligence. That is what is in the public protector's report. Yes or no?
It is correct, Chairperson.
Thank you. Right. Now, then it then says, in a meeting held between the Inspector General of Intelligence, Dr. Sitluma Maru, Dintwe on 31 January 2019. Let's pause there. That is the meeting, apparently, that was played here on Monday for a long time. Chit-chatting with Miss Govender and this one and that one. You agree?
Yeah, just to be sure, we're on 5/2/26.
25, sorry, Mr. Panrahma.
Okay.
We're still on 25.
Okay, thank you, Chair.
Okay, good. Now it says this, Mr. Dintwe, that's the Inspector General of South Africa, confirmed that the office of the IGI had indeed previously investigated allegations of an intelligence unit within SARS and confirmed the existence thereof. You see that?
Yes, Chair.
Yes. In other words, in the meeting that was played here, Dintwe, among other things, confirmed that there was an investigation and which confirmed the existence of the rogue unit, so-called. Okay.
If you simplify it to that, yes, Chairperson.
Thank you very much. Right. Now, then the 26 is the one that then gives it a bit of context. It says, apparently the then Inspector General, that would be the late Advocate Faith Khadebe, conducted an investigation on the intelligence unit within SARS and issued a report on 31 October 2014. You have no quibble with that?
No, Chairperson, it is correct.
Yes, it's in straight lines. Okay. And then, which I was reliably informed that it was in the custody of the former Minister of State Security, Ms. Dipuo Letsatsi Duba, from whom I tried to get a declassified copy of the report without success. You have no quibble with that as well?
Yes, that's what it says.
Yes. Do you know, as a matter of fact, just to clean this up, Chair, that so much did the public protector make those attempts to get the declassified report that at some stage she even laid criminal charges against the minister?
Yeah, I read about it in the newspaper. Yes, Chairperson.
Yes. In fact, it was what one might call a skirmish. I think the minister also laid criminal charges against the public protector in that process. Are you also aware of that?
Yes, Chairperson.
Thank you. Right.
Chairperson, just if I might ask to go back to 5.2.24.
20?
24.
Yes, let's do that.
Sorry, no. It's the one where reference to Advocate Sikakane.
Yes.
That paragraph that you just read out first before you took me.
That was 25. I didn't go to 24. That was 25, but we can go wherever you want.
Just the one where there's reference to Mr. Sikakane recommending that the matter be referred to the inspector.
Sorry, Mr. Van Rochberg. It's 5.2.25. I'm just saying it loud for the person who's operating. 25. Right? Yes, we are back there, Mr. Van Rochberg.
No, sorry, Chairperson. There's a paragraph that was read out before 5.2.25.
Oh, I see.
To the Sikakane recommendation.
That's 16, probably. The only other one that I read was 5.2.16, the one that said
that's the one.
Was commissioned by former SARS Commissioner, Mr. Ivan Pillay, and so on.
Yes. So, Chairperson, I did not agree with the contention that brought us to what's being laid out before the committee now. That the Inspector General report was an outflow of the Sikakane report for the simple reason that the Sikakane report is dated 5 November 2014, which is not evident in this paragraph. Whereas if you go to paragraph 5.2.25,
26, you mean?
And
It's
26,
dated.
sorry, you will see that, in fact, by that time, the Inspector General of Intelligence report had already been concluded.
Good. That's exactly, I don't know which part of this is not clear. I do not care whether in fact, it was a coincidence or whatever.
Okay,
I'm saying,
then it's fine,
yeah.
Chairperson, because that is what I was asked.
all right.
Okay, thank you.
I've said it to you. I've said it to
Proceed,
Bao.
Advocate Mpofu.
Anyway, all right. Let's move on. Okay.
Just sorry, Chip, I don't want to interrupt there, but I think this point is rather important. I hear what Advocate Mpofu is saying, and he's reading from the Public Protector's report, but then the Public Protector is wrong as well. For the simple fact that the dates indicate that the other report was completed before the other one, so the deduction that the one was built on the other is factually wrong, and the committee needs to understand that and take that into consideration.
Yeah, but the Public Protector is wrong with what? When did the Public Protector say what you're saying?
Sorry, Chair.
Go ahead.
You are reading from the Public Protector's report, 5.2.5 or 5.1.6. In that report, the claim is made that the report from Intelligence General was based on the other report. It seems that the facts indicate differently, and I think that's important for the committee to take cognizance. So if you say you're not interested in that, I understand that, but I'm interested, and I think the committee is as well.
Okay. Well, I hope this committee is only interested in the facts, not some fiction, because all I have said.
No, Advocate Mpofu, I would want you to tone down.
All right.
That.
Okay.
Please.
Actually, I don't appreciate being interrupted in my cross-examination, but let me take your advice, Chair. Dr. Honorable Mulder, I have never and I will never say that the Public Protector said that the one report was as an outcome of the other one, because she simply has never said that. That's what I'm saying. All she says is, and I'm reading this for the umpteenth time, the Sikakane report recommended that the activities and functions of the SPU be investigated by the Inspector General of Intelligence, full stop. That's all she said. I've never said what you're attributing to the Public Protector.
Okay.
Thanks. Thank you. Let's go.
Honorable Order, I'll come back.
All right.
Honorable
Now-
Order, just pause, Advocate Mpofu.
Sorry.
Yes, Honorable Chairperson, and good morning to everybody. I'm also a bit concerned with paragraph 5.2.25, I think.
Yes.
Advocate Bao was about to just point out what, the actual recommendation in that report, the Sikakane report actually was. And I think it's important, we just want to hear her if possible, because she didn't quite get a chance to indicate, because what we had on the screen was the interpretation of the Public Protector around what the report recommended. And she was trying to put it on record, what actually was the recommendation in the report. So I would really appreciate it. I beg your indulgence on this, Chair.
So you're requesting that we have that read to us?
Yeah,
The
by
Sikakane
Chairperson. Yes,
recommendation.
the recommendation, the point that she wanted to make, for her to make that point, because I think it's
Okay.
very important that we get, that also on record.
Just pause, Advocate Mpofu.
Yeah. And I was going to say I have no problem.
I don't think that is a train smash. Can we do that?
I don't have it to put it on the screen because our operator doesn't have it, but we'll make it available. There's a series of recommendations in the report, but I think the one that relates to this is 190.4, which is on 217 of the record. It says, in respect of the unlawful establishment of the Special Products Unit /NRG/HRIU, the following is recommended. Sub 1. As we understand that the Inspector General of Intelligence is already investigating Ms. Walter's complaint, the activities and functions of this unit must be specifically investigated by the Inspector General. Alternatively, we are of the view that the Commissioner should recommend to the President that Judicial Commission of Inquiry with powers of compulsion in terms of Section 3 of the Commissions Act 8 of 1947 should be appointed. Such commission, if considered, and then it goes on to what that commission should do, which is not relevant to the debate, And then it goes on in sub 3, which is SARS should ensure that proper structures of cooperation between SARS and government agencies statutorily tasked with intelligence gathering and crime investigation are established in order to assist SARS with capacity. I was trying to point out earlier that I think Mr. van Loggerenberg and Advocate Mpofu were talking across each other on different sections of the Sikhakhane report.
No. Thank you. Can I carry on now with my cross-examination?
Yes.
Thank you. So from what has been read, it looks like the situation is even better than what I was describing. What Ms. Bauer has now read to the committee is that Advocate Kakane was even aware that the IGI was conducting a report and made recommendations that whatever was read. Would you agree with that?
It appears to be the case, Chairperson.
Thank you very much. So thank you. So it's even better. All right. Thank you, Honorable Gond. So let's go back to where we were.
I should just add, Chairperson, that it appears that Mr. Sikhakhane was unaware at the time when he published his recommendation that the Inspector General of Intelligence had already concluded the investigation.
Correct. Because of what you pointed out, the November, October thing. That's correct. Yeah, I agree with you there. All right. Now, the point though, which is the business of this committee, is that okay, we've already said we agree that he was reliably informed, she being the public protector was reliably informed that it was in the custody of the former minister, and then they were fighting it out. Now, 27, the next one. He says, in an attempt, the public protector says, in an attempt to determine the veracity of the allegations of the existence and activities of the intelligence unit, I sought more information from the Inspector General of Intelligence, that's Dr. Dingtwe. This information was attributed to a report by the former IGI, Advocate Khadebe, dated 2014, the OIGI report. You and I, we've gone through this now. You confirm that?
Yes, Chairperson.
Thank you. Then he stated that the report can be requested from the Minister of State Security as the lawful custodian thereof, right?
Yes, Chairperson.
Okay, then the rest I'm just going to paraphrase. It's the thing about the fight, the criminal charges and so on. We've already covered that. Now, if you go to, okay, no, let's pause here. What we've now discussed, including the discussions between Dr. Dintwe and what is in the report, in whose custodianship it is, and so on. All that was, we now know, sitting here, discussed in the recording that was played here, correct?
That's all that's contained in the Rule 53 record, Chair.
Exactly, that's my next issue. And that recording that was played here comes from the Rule 53 record, as you correctly say, which was supplied by the public protector, correct?
Yes, Chairperson. And it related to a date 31 January 2019.
Yeah, whatever. No, the gist of my question is that Rule 53 record was supplied by the public protector. The thing that was played here we wouldn't know about it if the public protector had not discovered it.
Well, that and the fact that on the 31st of January 2019, the public protector was in fact in possession of the report.
Yes, fine. I don't even know
what was not in the Rule 53 record.
It was in her Rule 53 record with whatever you're saying. Okay, good.
It was not, Chair.
Yeah. Pardon?
The Inspector General of Intelligence report was not produced in the Rule 53 record.
I'm not talking about the report, Mr. Van Loggerenberg. I'm saying the recording that was played here on Wednesday
Yes, I'd agree, Chairperson.
came from the Rule 53 record that was discovered or supplied by the public protector advocate
Thank
Mkhwebane.
you. Let's proceed.
Thank you. All right. So she has a discussion about all these things, and then she, of her own volition, discovers it in the Rule 53 report. But let me just close up the following point, which might be important for another reason. If you go to 5.2.32, just to show the extents and lengths to which she went to try and get this report legalized, so to speak. She says at 5.2.32, and hopefully we'll get evidence on this when these witnesses are called. I have since requested President Ramaphosa's assistance in facilitating the availing of the declassified report by the Minister of State Security to no avail. You have no reason to dispute that she's lying about that?
No, in fact, it's reflected in the Rule 53 record.
Yes.
Yes.
Okay. Yeah. And then she says, this is the punchline which seems to confuse everyone, and which I will show you just now that the court was completely wrong and you found. Then she says, in light of the above mentioned, in other words, of all these things that you and I have now canvassed, and in terms of the powers vested in me by Section 181, 2 and 3 of the Constitution, I have it on good authority that the findings of the OIGI report inter alia were that. Okay, and then A, SARS created a covert unit utilizing covert and intrusive methods, which was not in line with the SARS mandate and in violation of Section 2091 of the Constitution, which only empowers the president to establish any intelligence service. In other words, it established the rogueness, what I've called for shorthand, the rogueness of the unit. You agree with that? Not that you agree with the conclusion, but you agree that that's what she says is contained in the IGI report, correct?
Correct, Chair. It's actually a direct quote from the report.
Absolutely. Then she says the establishment of an intelligence capacity with SARS, a capability exclusive only to legislated intelligence services, was illegal. Again, same point, rogueness, correct?
No, I only accept that what you're reading to me, Chairperson, is that it's a direct quote from that reviewed and set aside Inspector General of Intelligence report.
Yes, Mr. Van Loggerenberg, please, let's try not to waste time. I've said what you're saying, that you don't, I'm not saying you're accepting the content. I'm saying you accept, okay, let me put it this way. Do you accept that if these two things are true, that would be a demonstration of rogueness? In other words, if SARS, in violation of Section 2091 of the Constitution, which only empowers the president to establish intelligence services, and as the establishment of intelligence capacity, a capability exclusive only to legislated intelligence services, which is illegal. If that is the case, that's an indication of rogueness.
Yes, Chairperson, if SARS did that, it did that, hypothetically speaking, one way of describing it, I imagine, could be using the term rogue. Yeah,
no, and I'm not doing it to be facetious. I'm using it as shorthand. Simply, as I said, maybe I'll use lawfulness rather unlawfulness. Yeah, but you know what I mean. You agree with what I'm saying?
Yes, if it's your preference to then use another term, so be it.
Yes, because I just want to move on, Mr. Van Loch. I don't want to quibble about stuff that is not going to assist this court.
Just a pause, Advocate Mpofu.
Sorry, Chair.
Honorable Maneli.
No, I just want, for purposes of clarity on my side, so that I know which report we're dealing with. The first point raised about the Sekakane report was more of a reference to the Inspector General of Intelligence. On this point, 5.2.34, is this a direct reference to the actual intelligence Inspector General's report, or it's still referred to as in the Sekakane? I think for me, the important part is whether this then becomes an admission that you are using a report, whether acquired in one way or the other, or it's still reference to Sekakane, just to be sure that we're talking to the same point when we want to come back and ask questions. Thank you.
Thank you, Honorable Maneli. Advocate Mpofu.
Thank you, Chair. No, I get the point. Honorable Member, let me just, if we go back to 5.2.33, you see that she says, I have it on good authority that the findings of the OIG report inter alia were that. After that colon, up to the word activities at the end of 5.2.34, that's from the IGI report.
Chairperson.
Thank you. Yeah. So
Understood.
thank you. Thank you very much.
Thank you. Just hold, Advocate Mpofu.
My apology.
Honorable Mulder.
On the same 5.2.3.2, please. If you can just have that there.
Which one? 5.2.
2.3.2. Yes. And 5.2.3.3. The point I'm trying to have clarity on is Advocate Mpofu started off by asking Mr. van Loggerenberg this morning, where in the report does the public protector deny that she had a copy or have hold of the report of the Inspector General of Intelligence? That's what I heard, if I'm not mistaken.
Chair, if I may intervene, can I deal with the witness, please? I'm begging you. Otherwise, this is really going to derail my cross-examination. I can't be asking the same questions and then attempts to answer it for the witness.
Let's allow him to complete. So,
Right.
Honorable Mulder.
Thank you.
Chairperson, I just want to make the point. This is not a jury. This is a committee that wants to understand the process. And if I want to ask and understand, then I would really want to be answered, but Mr. Mpofu doesn't want to be disturbed. So complete your, from my perspective, I'll ask you the question afterwards. Thank you.
Yes, thank you, Chairperson. The directives were adopted yesterday, and the directives say that the evidence leaders must lead the evidence. We must cross-examine. Thereafter, the members must raise their questions. There's a reason why it's exactly to avoid this kind of thing, where my cross-examination is being interrupted. I don't mind, I must say it openly, for clarity-seeking questions. For example, the one that Mr. Honorable Maneli, I know this is not a court of law, but what I don't want is to go into the merits of answers that I'm extracting from a witness, and because that's a completely different business, which is wrong. Thank you. Now, Mr. van Loggerenberg.
Yes, Chairperson.
Thanks. So anyway, when I was clarifying the issue to Honorable Member Maneli, I think that covered my next question. So I'm not going to ask you. Now, I'm saying, okay, after the word activities at 5.2.3.4, then it says the KPMG report, right?
I'm not seeing it on the screen, Chairperson.
Okay, take it from me.
Yes, okay, I see that.
Okay, then in other words, they're now dealing with something else completely. Now, it comes to the question which, as I say, has now been preempted, which I really don't appreciate. The question is, In the section that you and I have dealt with, we've now agreed that the discussion of the IGI report is for the reasons that we have explained, covered under the heading, the Skakane report. And this is now the end of that discussion. Now I'm saying, where in this, what you and I have gone through, is this part where you say the public protector emphatically states that she did not have the IGI report? Where is that?
If the person controlling the screen can just go up slightly, please.
I'm sorry, so I'm very sorry to do this, Mr. Van Loggerenberg. Let me put the question even in broader terms, and it will be clear just now why no. In fact, let me do this with your permission, Chair. In that spirit of killing two birds with one stone, go to paragraph 113 of the rogue unit judgment, so-called rogue unit judgment. Oh, it's bundle A, page 4016. Yeah. Got it. 113, please. Okay. Can I just carry on, Chair? It's a small thing. I'm sure when it comes up, it will come up.
Okay.
If I'm misreading, I'll be found out. Yeah. Okay. 113 says, this is what the judgment says. It says what you are saying wrongly, Mr. Van Loggerenberg. So the public protector relies on this report despite explicitly stating that she has not seen the report. Do you see that part?
Yes, Chairperson.
Yeah. And it says she relies on it because she has it on good authority that it was found in the report that part, the second sentence is correct. We've just established that. Okay. And then go to 1. I'm sorry, do you actually have a hard copy or any version of this? Okay, thank you. I think we're there. Okay, I've just read the first sentence and the second one. We can move on to 115. Can you see it, Mr. Van Loggerenberg?
Yes, Chairperson.
Right. Then again, the judgment makes the same point at 115. It says, despite the fact that, and I'm saying this at the back of your mind, you must understand this is all leading to a devastating finding that the public protector is dishonest. So, but park that thought. Yeah. It says, despite the fact that the public protector, according to the report, underline according to the report, has never seen nor verified the contents on findings of the OGI report, she ordered the minister to implement it within 90 days. The emphasis is on the first part. Despite the fact that the public protector, according to the report, not according to anything else, has never seen, in other words, they agree with you that she emphatically said she has not seen it. Then 116, Chairperson. They say, it is difficult to understand on what basis these sections of the Constitution can notionally grant the public protector the power to rely on a report that she herself has not seen, because this is what she says in the report. So again, they agree with you. All right? The report, assuming, is the report of the public protector.
Yes, Chairperson.
Yes, and then it goes on and on. The thing about counsel, and we don't have to deal with it now. Maybe I'll deal with it with Mr. Pillay, because he was a litigant. But go to 120. Sorry, 119 first. The public protector now considered that despite explicit statement in the report that she has not had sight of the OIGI report in preparing, she has in fact had the OIGI report and in her possession when she drafted the report. Public protector now claims she subsequently received the report from an anonymous source who left it at her office. Firstly, that last one is just, she had said, we had in the conversation that that had happened even before she went to see Dr. Dintwe, but that's not an important point I want to make for now. It's just factually wrong. But at 120, that's the punchline, which is before this committee. This turn of events is disturbing to say at least, and it is difficult to label the public protector's conduct in that regard as anything less than dishonest. In other words, the issue that is brought here before this committee to impeach the public protector is not the build-up, so to speak. It's the fact that she's dishonest. And that dishonesty owes to the fact that, according to you, Mr. van Loggerenberg, and this judgment, she explicitly, emphatically, with whatever word you want to use, stated that she had not seen the OGI report. Now, here's the question. Where can you assist this committee to tell us where in the report she has explicitly, emphatically, whatever you want to call it, stated that she had not seen the report?
If you can go back to the report, please, Chairperson.
Which one? The public protector's report?
Yes, Chairperson.
Yes. Which paragraph?
If my memory serves correct, somewhere around 15.2.23.
15 point? Repeat that.
15.2.23. Somewhere around there. If I can just see that page.
Okay. We'll get there.
2. Okay, it's on bundle A, page 4217. $76. Are you finding it? Sorry, Mr. Van Loggerenberg, can you just repeat the paragraph you're referring to?
I think 15.2.23.
I don't. Okay, I stand corrected, but I don't think the report goes that far. But let's just.
It's around there where she indicated she turned to the president for assistance.
Okay, no, you mean 5, yeah. Paragraph 5.
I'm sorry, I apologize. Sorry.
Sorry, yeah, no, that's why I was totally confused. Yeah. So, okay, sorry, no, it's fine. It's a mistake. So you are taking us to 5.2. The reference to the president is, you'll find at 5.2.23. Sorry, 32. Yes. Thank you. Okay, 5.2. Are you still with us, Mr. Van Loggerenberg?
Yes, Chairperson. Can the person please just scroll up a little bit?
Please scroll up for Mr. Van Loggerenberg.
The sentence starts with, in an attempt to verify the veracity, or something similar to that.
Okay, that's
there you go. 5.2.27.
Yeah, just a minute. 129. So, okay, no, you can carry on. Sorry, I've just lost my.
Go ahead.
Just go ahead. I'll still find it.
Okay. So in July of 2019, Ms. Mkhwebane states in an official report under her office position as the public protector, she states at 5.2.27, in an attempt to determine the veracity of the allegations of the existence and activities of the intelligence unit, I sought more information from the Inspector General of Intelligence, Dr. Setomaru Dintwe.
Correct.
This information was attributed to a report by the former Inspector General of Intelligence, Advocate Faith Hadebe. That then means emphatically that at that point in time, Ms. Mkhwebane doubted the veracity of the allegations, and she sought out to determine the veracity of that.
Can just try and repeat that? I don't know what you're talking about. You're saying
in an attempt to determine the veracity, you don't need to determine veracity of something which you believe veracity is when there's doubt.
Ah, I see. So you are reading that to say she wanted to determine the veracity of the IGI report.
No, you're not allowing me to conclude.
No, take your time, Mr. Van Loggerenberg.
Okay, just hold back, Advocate Mpofu. Please go ahead, Mr. Van Loggerenberg.
All right. So in July 2019, this process is described by Ms. Mkhwebane that there was an attempt to determine the veracity of the allegations of the existence and activities of the intelligence unit. That attempt was then to seek more information from the Inspector General of Intelligence. This information, which she sought to determine the veracity, was attributed to a report by the former Inspector General of Intelligence, Advocate Faith Hadebe. He stated that the report can be requested from the Minister of State Security. Now, if Ms. Mkhwebane had the report, everything that follows, subpoenaing the Minister of State Security, laying the criminal charges, writing a letter to the new Minister of State Security, opening a criminal case against the Minister of State Security, writing to the President and everybody else, is an emphatic denial that she was not in possession of that report. If she was, it would not, it would simply have said, I have the report, here's the report, this is what it says.
Right. Are you done now?
Yes, Chairperson.
Thank you. So what you've just said now is all that you rely on for your statement and the statements contained in the judgment, that she explicitly and emphatically stated that she had not seen the report. Am I right?
Well, it continues. She then ascribes her knowledge and insight of the report to some kind of good authority.
Yes. Okay. Now, everything you've said.
And having said that, then my answer is yes, Chairperson.
Thank you. Thank you very much. So we know now it's those two issues that justify you and the judgment saying that she explicitly and emphatically stated that she had not seen the report. Thank you very much. That's
unless Ms. Mkhwebane is prepared to state that she did have the report all along. And then that begs the question why it wasn't produced to the affected parties and why it wasn't produced in the Rule 53 record and why the matter was opposed in the interlocutory and whatever was stated on oath before court there.
Right. We're going to get right there, Mr. van Loggerenberg. But I just want us.
It's not for me to. It's not for me to speak for Ms. Mkhwebane or for the committee.
No.
We do have a spokesperson.
Yes.
And Mr. Mkhwebane has you correct there. Thank you.
Yes.
Continue, Advocate Mpofu.
Thank you, Chairperson. And for now, I'm her spokesperson. No, Mr. van Loggerenberg. No, if we gave you that impression, we apologize. We just want you to speak for yourself. You are the one who says she emphatically said she had not seen the report. So you are your own spokesperson.
I've answered that question, Chair.
Yes. No, but so that other stuff was unnecessary. Just stick to answering the questions. So we've now established that the statement, which is attributed to Ms. Mkhwebane, which has led for us to be sitting here because she is now dishonest, as far as you are concerned, is based on these two things. Paragraph 5.2.227 and 26. That's the good.
I don't think it's necessary to repeat, Chair. I've answered the question and it will reflect in the record. I've said a few things.
Okay, I'm doing it for the record, Mr. van Loggerenberg. You don't have to be rude. Just work with me here.
I apologize, Chair. I want to take time.
If I repeat it for a particular reason, if you don't mind.
Fine.
Thank you. Right. Now I'm saying to you then that let's go to 5.2.27, the one that you say justifies your conclusion. Can you see there that it says, in an attempt to determine the veracity of the allegations of the existence and activities of the intelligence unit? It doesn't say to the veracity of the report. Can you see that
person, correct?
Agree on that? Yes. Yeah. So where in the world are you then finding that when she wants to determine the veracity of the existence of the unit, that has anything to do with whether or not she has seen the report emphatically?
Because the next sentence reads, this information was attributed to a report by the former Inspector General of Intelligence.
Yes.
Which is the report in conversation. The next question then is a response. Dr. Dintwe stated that report can be requested from the Minister of State Security. We've listened to the conversation. We've listened to how there were debates between the Inspector General of Intelligence and Ms. Mkhwebane on how exactly she could access it. On the 31st of January 2019,
Thank you, Mr. Van Loggerenberg. Yes, that is so. But when we listen to that, and if it has to be played again, it will be played again. When we listen to that conversation, it was clear there, and I'm paraphrasing here, please don't quote me verbatim. You can say you agree or you don't agree. It was clear. I'm just putting to you as a proposition. I'm just saying you can agree, disagree, or say I don't know. The proposition I'm putting to you is that it was clear from that conversation that the participants in that conversation were aware that, one, the report, the public protector, I think, said somebody had dropped it at the door or at the gate. I'm not sure which one.
But Mkhwebane said so.
Yes, that's the public. That's Ms. Mkhwebane is the public protector. Yeah. So
Yes.
What you call Dr. Dintwe, I think, or again I stand corrected, or Ms. Govender said that in any event it's in the public domain. Some words to that effect, and I think Advocate Govender made some other comments, and I don't know if this was. Yes, and I think, sorry, I was just verifying. There was even mention, but don't worry about this because we'll have to play the thing if we have to, even when you're not here. There was also mentioned by either the PP, I think it was the PP, that the report was actually in Noseweek, in a publication called Noseweek as well. Do you agree with that? Or don't you know, yes or no?
I don't know, Chairperson.
Good. Okay.
Advocate Mpofu, we'll pause there.
Thanks.
And take a tea break and be back at 10:02.
Thanks, Chair.
Thank you. So it's a tea break, Mr. Johan van Loggerenberg.
Recording stopped.
Help yourself. We will be back at 10 to 12.
Thank you, Chairperson.
Thank you.